Good afternoon, everyone. Welcome to our session today. We're very honored to have Susan Crockin, who is an attorney in the reproductive field. I'll read a quick introduction of Susan's background and history. She's been involved for a very long time and has really been a trailblazer when it comes to law and policy as it relates to assisted reproductive technologies. Susan has continuously represented individual and institutional clients involved in the legal, policy, and ethical dimensions of assisted reproductive technologies and adoption. Susan established the Crockin Law and Policy Group, PLLC, in Washington, D.C. in 2012, following her move from Boston, where she had established the Crockin Law and Policy Group, LLC, one of the country's first law firms devoted to exclusively the legal issues surrounding assisted reproductive technologies and adoption. She's been instrumental in much of the developing ART law and policy in Massachusetts, including the Massachusetts infertility mandate. While in Boston, the firm represented numerous institutional ART clients, over 1,000 intended parents, donors, and gestational carriers, as well as 3 of the largest adoption agencies in the state. So Susan, welcome. Thank you so much for joining us today. We're very honored to have you.
Thank you. It's wonderful to be with you all. Thanks for having me.
Maybe we can start off by talking about, you're a lawyer by training. How did you get into reproductive health and ART and adoption? What was it that drove you to this field?
Well, I was a public defender, so it was an obvious transition. No, but when you mentioned the infertility mandate, I worked on that as a consumer. My husband and I were infertile and trying to figure out how to build a family in the 80s, which I know for many of you was the dark ages. And so we ended up doing IVF, we ended up adopting, we ended up with a blended family that was wonderful. And along the way, we as patients worked on the mandate. And that was 87 and 88. And if any of you were practicing or around, I don't know how many of you are of what, decades and ages, but there really was only one IVF center in the country that was going, full blast, and that was the Jones Institute in Norfolk. So a lot of us were patients there, met some patients who said, well, our insurance is covered because we're from Maryland, and we came back and wrote the mandate and worked on it for 2 years. And, time marched on a little bit, and I kept being called about, what about this? Why can't I get my insurance to cover my infertility? How do I adopt? How did you all do it? And finally decided, the legal issues here are just going to keep getting bigger and bigger. And 1988, I opened my law firm. And the joke, David, was that I went to every doctor in Boston, most of whom I knew as a patient, and said, I'm opening this practice. And I always joke and say to a man, because it was a very male field then, including many of the people who are your colleagues, said, what legal issues? And so I said, well, you know what, here's the deal. If you find a legal issue, I will be working in my home office with my 2 kids for adoption and IVF. And if I don't get any clients, then I will be a full-time mother. If I do, it's my pleasure to help people. And it just took off from there. And, you and I spent a lot of years on this, and the issues have not gotten easier.
No, it's very, very forward thinking. And you really have been at the forefront of a lot of these cases that have set precedent. Tell us, before we get into the specifics, and there have been questions, and I know there's obviously, because of the Dobbs decision, we're going to dive into that and talk, because up until this point, there's always been the Roe versus Wade kind of, I would call it maybe bumpers or safety net for the ART field. But before we go there, tell me a little bit, and tell us a little bit about the relationship with Dr. Howard and Dr. Georgeanna, who are just honestly started IVF. We've had Elizabeth Carr on, we've interviewed Elizabeth, and Dr. Howard and Dr. Georgeanna really brought IVF to the United States, and we're also very forward thinking.
They were a remarkable couple, and they, Dr. Howard, my husband jokes that if Dr. Howard was not 100 years old, he thought I might have left him for him, but then he went on to be 104, and he was vital the whole time. So I told my husband he should still worry. Howard and Georgeanna Jones were like nobody else I've ever met or known. They had the vision that IVF could happen in this country, and their personal story was, remarkable. And I'm sure Elizabeth Carr talked to you about some of that. They were mandatorily retired from Johns Hopkins, and they were on their way down to Norfolk, Virginia to help this fledgling little medical school open its doors and be the OBGYN chairs. And Louise Brown was born. Did she talk to you about this?
No.
It was just so I'm from Norfolk, so that's another coincidence. And my father was one of the several businessmen who started this little fledgling medical school, knowing that some years later his daughter would be a patient there. And Howard and Georgiana Jones came down, Louise Brown was born, and they were unpacking their suitcases when she was born. And a reporter called. Dr. Georgiana was a beloved gynecologist in Baltimore. And a reporter called and said, could this happen in the United States? Could we have IVF? And Dr. Howard said, yes. And they said, what would it take? And he said, money. And the next day, one of Dr. Georgiana's gynecology patients called and said, how much do you need to start?
Wow.
And they were off to the races. And I started interfacing with them in the mid 80s. I was there when, there were protests in Norfolk about this is, it's very much like what we're hearing now with the anti-abortion stuff. They accused them of baby killing. They said they were taking unhealthy embryos and babies and putting them off in the dark corners and making sure they didn't live. They actually brought a defamation suit against the local newspaper and got a lovely settlement that all went to research. And for a long time, they were, people talk about Dr. Howard and Dr. Georgiana as medical pioneers, and I talk about them as ethical and policy visionaries, because Dr. Howard always said to me, and he was a wonderful mentor to me my whole career, you can't do this without understanding the legal frameworks, the policy, the ethical issues. He started the first ethics committee at ASRM. And so, I could go on forever. There's a book behind me with their picture, because I just, it's sort of my North Star and keeping in sight that, this is what we're doing and why we're trying to do it.
And the ethics around it, I think, and the morals at the time that they started, the idea of having conception, fertilization happen outside the body was, nobody did it. It was undone. And there were questions morally or ethically, was this, okay? It was against nature. So having that framework is so important for all of us in what we do, to be able to spell out, here's how to do it in the correct way, in an ethical way.
Absolutely. And another component of what they did, I think, is try to help us with language, which I'm a big language person. The lawyers, I joke and say doctors make babies and lawyers make footnotes, and we try, but they, Dr. Howard would talk about pre-embryo, and then all the embryologists would laugh at him and say, just call it what it is, an embryo. And I feel like, here we are decades later talking about pre-embryos and fertilized eggs in order to try to understand the difference in fetuses in utero. And, they were just remarkable in some of the things that they did. The first ethics committee created the definition of an embryo that I still think is the best one I've ever seen. Respect for the special respect for the potential for life. It's not the same as life, but it's really special respect. So
that's an excellent segue, and I'm going to share my screen now, because I think there's some points to make, and that's a great segue to talk about really ART law for the non-lawyer, and what are some of these key principles, because you just talked about language. And so much of, as we delve into the Dobbs decision, which has now kicked things back to the states, so much of it is about the language that is used in these laws. And so maybe we can talk a little bit about, just kind of the law for dummies very quickly, and then we'll talk about this decision and the history before it.
Absolutely. And, it isn't law for dummies, it's law for non-lawyers. I always say, most of the folks I talk to decided not to go to law school for very good reasons. So here's the, sort of quick version. So this is a really framing slide, if you are, so just so that everybody's leveled up and talking about the same thing. So laws come from two places. They come from the legislatures. That's what we're hearing in the news all the time. The state legislatures who are scrambling to pass anti or abortion laws, bans, or protective laws. And that's what the state legislatures do, or the Congress. And then the courts. And that's when, you get a debate, a fight, and you end up in court. And those are case law, court opinions. That both of those things happen at the federal and the state level. And the US Constitution is sort of, it's the big thing, and it's the umbrella under which everything else sits. You can't pass a state law that violates the US Constitution, because federal law, we are the United States of America, not a federation of 50 states. And so federal law does what's called preempt. It preempts if you have an inconsistent state law that violates the Constitution, it's got to fall. So, before Obergefell, which said same-sex marriage, you could have every state deciding what they wanted to do about marriage. But once the Supreme Court says, nope, there's a constitutional right to marry who you love, no matter what sex, you can't have a state law that says you can only be a man and a woman. Now, nothing stops the state from being better, greater protections under their own state constitutions or legislation, as long as it doesn't violate the federal law. So Kansas is had the election August 2nd, and they said, we have a state constitutional right to abortion, and that's fine. The only thing Dobbs did, which is a big only, is took away the federal protection, which is a huge deal. We'll talk about it, but it doesn't preclude a state from doing better. The last couple of things on this slide are just to explain categories of laws. So family law is what decides who's a legal parent, who's their child. And that's always been a state law question. So for those of you, and I know you do a lot of this work between states with third parties, donors, and surrogates, the lawyers in the background and the participants are trying to figure out what state law controls. So every state is somewhat different, and it ends up being somewhat of a patchwork, if you will. And then the last concept is a fancy word called precedent. And precedent means, do you have to follow the law, the legislature or the court? And it depends on who decided it and at what level. So if it was the Supreme Court, you have to follow it, which means, we can no longer say there is a protection for abortion under the Constitution of the United States. But you don't have to follow any other state's laws. And Massachusetts, somewhat like California in this field, has been a trendsetter in many, many ways. I mean, we had gay marriage in Massachusetts, and I say we because I practiced there for so long before the Supreme Court did, because the attorneys at GLAAD said, we are going to make this happen in Massachusetts. So there's nothing wrong with that. On the other hand, New Hampshire didn't have to follow it. And then the last point on this slide is just that in any state, you only have to follow the higher state. I always think of it sort of as a pyramid. If the highest court of the state says, a typical one is, what do you do with divorcing divorce cases on embryos? Yes, you have to follow it. Massachusetts, we've got AZ versus BC, but one trial court doesn't have to do what another one says. So if Middlesex and Suffolk disagree, that's fine, until a higher court tells them both of you have to follow us.
And that's actually, so that's a good point, because one of the things that we see in some of these states right now is one county or a district is making a law, but if the overarching state Supreme Court hasn't ruled, then in that county it's legal to have an abortion, but in the neighboring county it might not be.
Yeah, and also, I mean, in the ART field, dude, for years, people would forum shop all over. They would shop into, if the parents for surrogacy were in Middlesex and the surrogate was in Suffolk, nobody liked Suffolk. It's a very strict court. It's very Catholic historically. And so you would, if you could, you'd go to Middlesex. And so that was happening all the time. And even within a county, people knew which judges were more sympathetic. So when the law is unsettled, everybody goes and tries to find a sympathetic judge, and you worry that you're going to not find that judge, or your family's going to need you to go to court on a day when he or she's out sick with COVID. So yeah, it really creates a lot of chaos is probably too strong a word, but certainly inconsistency and unpredictability.
So that's a great kind of framework about the courts and the laws. Now, when it comes to specifically different cases, a lot of this is based on precedent. And so we have on this slide some of the precedent that's been set by different states and by different courts. And so maybe we can talk a little bit about this. So SCOTUS is the abbreviation for the Supreme Court of the United States. But this first kind of pre-1978, so pre-Roe, there were some cases that were decided. Yeah.
And this is an abbreviated list, but what I used to say pre-Dobbs was that you have to understand there is a constitutionally recognized right to privacy under the 14th Amendment. And what the Supreme Court had said, expanding each case essentially was, yes, it applies to this. So In 1942, there were these horrible situations of women who are being forcibly sterilized. And Skinner versus Oklahoma is a case that says you cannot do that. Even for people who have diminished mental capacity, and there was a trend at the time to let's sterilize. There's a horrible quote from one of the justices, 3 generations of imbeciles is enough. And so that case said you cannot violate a woman by sterilizing her without her consent. 1972 is Eisenstadt versus Baird, and that was people who came to the court and said, we can't get contraception because we're not married. And the court was asked, well, do you have to be married to have the right to decide to prevent contraception to prevent procreation by contraception? The court said no. The right to decide whether you want to be a parent or not a parent, to procreate or not, is an individual's right, not a married couple's. So that became another important ruling in the firmament, if you will. And this is all the precedent for the country. And then 1973, Roe v. Wade came along, and what the court said, as we all know now and are really quite aware of, is there is a constitutional right to privacy under the 14th Amendment. And that in turn leads to a right to procreative decision-making. And women have a right to decide what to do with a pregnancy until viability. And what they said is the person does not include the unborn, and that at least until viability, a woman and her doctor can decide what to do with pregnancy. Once you get to viability, then there's a balancing act that happens. And one thing that's not on this slide, but is important to recognize, is that constitutional rights are considered so important that you can only invade them or interfere with them if you meet a very high standard. It's called strict scrutiny. And you have to prove that there is an interest that is so important it can overrule the privacy interest. And so that's what Roe v. Wade said, was no, you cannot do that during the first 2 trimesters. Now, we all know that in 1992, after lots of skirmishing around the country, the Casey decision said, okay, we will uphold Roe. There is a right to privacy, which gives you a right to decide about abortion. But that trimester analysis is just not going to do it anymore. And they introduced a different standard, which is no undue burden. And that gave states a lot of leeway as to what they did in terms of, you have to have a second opinion, you have to go to a hospital, doctors have to have licenses, they can't be in an abortion clinic. All of those things are because the Supreme Court cut back the analysis from viability to undue burden.
The idea of a person's rights, though, I mean, that's a fundamental aspect of the United States. The Bill of Rights, the Constitution was written and created by the colonies of Great Britain, who wanted to have the rights to make their own decisions and not have some government, in this case, a king across a sea, tell them what to do. So it's really interesting that, with the Dobbs decision, the court is now saying that, yes, we're going to allow the government to make that decision, as opposed to have the individual be able to make that decision.
Yes, and I think what the majority would say back to you is, no, we're not doing that at all. We're simply properly recognizing that an unborn child is a person, and they have rights, and those are to be balanced against the woman who's carrying them. And so, that's the analysis on which they do it. They also say they have this fundamentalism or originalism that says there's nothing in the Constitution that talks about abortion. There's also nothing in the Constitution that talks about women being able to vote.
Yeah.
So they say this isn't a fundamental right because we can't find it in the original Constitution. But I agree with you. But that's the argument that they're making is, no, we're just balancing two lives.
So a lot of this then occurred, obviously IVF took place after Roe, the Roe decision. And, really in the 1980s, as IVF treatment started in the United States, it was still relatively small, a niche area. Obviously in today's world, I think 2 to 3% of babies born in the United States are a result of ART treatment. So it's really become a lot more, obviously we're helping people become parents. So not to necessarily go through everything, but the idea of the courts to look at these rights of embryos and other issues that occur, what does that do? You know, from a reproductive law standpoint, how does that kind of change things?
Well, I mean, it only stands everything we thought we knew on its head. And I think it's left us all kind of throwing up our hands and saying, where do we go from here? It is really hard to take the last, 60 plus years of thinking about reproductive constitutional rights and say they don't exist when it comes to half the population. And if we're trying, and the irony is, obviously IVF and ART are building families, whereas some people would say abortion is doing the exact opposite. I know Sean Tipton at ASRM says, we're the ultimate, ASRM is the ultimate right to life organization. But despite that, I think we have to seriously think about what can these pronouncements from the Supreme Court and from these states that are rushing to pass abortion bans do to impact IVF and ART. Because I've talked about this a little bit, the court wants to say they're only talking about abortion, but a lot of what they say can be applied to a lot of what we do.
So maybe that's specifically this decision that was rendered by the Supreme Court. Can you explain a little bit about how this came to be? You always have heard, especially as the court was being stacked with conservatives throughout the Trump administration, was looking for that right case to potentially change the status.
Sure.
So what is the case and what was the specific finding of the court?
So Mississippi had a law that said you could not have an abortion before 15 weeks. Or at 15 weeks, they were prohibiting it, which is pre-viability, which is incompatible with Roe v. Wade. And the question was, can that statute stand or not stand? So you have to look at that through the lens of Casey has already, since 1992, said you can nibble away at the right to abortion. And we're not just going to look at viability. So anti-abortion advocates have been looking for cases. This wasn't the only one, but it was a very good one because it was 15 weeks. It was crystal clear. And so that was the question. Does Mississippi's law violate Supreme Court law on abortion, meaning Roe and Casey? And this is the court that, as you said, was stacked with Federalist Society judges who believe in this originalism. And does the Constitution, can we find this right literally written into the Constitution? And they also are very much anti-abortion. Justice Coney Barrett was on record as saying things like, the safe haven laws, which are, drop the baby at the firehouse and you won't be prosecuted, would take care of unwanted pregnancies and things like that. So this court had a question in front of it. And one thing that wasn't on that slide, but could have been, was the fact that courts virtually always look to decide a question brought to them in the narrowest way that they can. It's called the holding. When you're in law school, you're supposed to get out your yellow highlighter and look for what's called the holding. And then after that, you can find a different color highlighter and mark what is the rationale and what else do they say. That's called dicta. What did they say that's interesting but isn't essential to the holding? So what was essential to this case was, can you have, consistent with the Casey no undue burden standard, a 15-week cutoff for abortion? They could have said yes. They could have, and a reasonable court that wanted to cut back on abortion would have simply said the Mississippi law does not violate constitutional right to abortion because it meets the no undue burden standard.
And so essentially draw a line at that 15-week and say anything earlier than that is still protected under Roe, but anything beyond 15 is now kind of fair game. But they didn't do that. They didn't do that.
They didn't do that. And they even could have said, we're not going to address 14 weeks and 6 days. We're being asked to address 15 weeks. So that's what we're going to address. So they didn't even have to say up to that is okay. All they had to say was at 15, it's fine. Instead, they took this as an opportunity to eviscerate Roe and Casey and the right to abortion. And so do you want me to explain what's on this slide, David, or no?
Yes, I think that would be great.
Okay. So, I mean, one of the things I like to point out is the decision was 6-3, meaning 6 justices voted in favor of upholding the Mississippi law. The opinion is 5-1-3, and that's because Chief Justice Roberts, who, as everybody's read about, is the center of the court and losing his center position, he wanted to do the narrow decision that is what we expected. He tried to convince his fellow majority. He was unable to, so he wrote a concurrence that said, I agree with the holding. I don't necessarily agree with all the other stuff my majority is saying. So that's why the opinion is 5 in favor of this broad, no right to abortion. Roberts, I'd say Mississippi's law is okay. And then the 3 liberal justices saying this is just a terrible thing you have just dropped us into. Justices can also write their own concurring opinions. They can write a separate dissent or a separate concurrence with the majority. And Thomas and Kavanaugh were with the majority, but they had something else they wanted to say, each of them, very different. And Justice Thomas, as you probably read in the paper, said, you know, like basically substantive due process, I don't like it. Due process is either procedural, you know, you can't arrest somebody if you have no reason to, and substantive is we have certain rights that the government isn't supposed to, sort of trample on unless they have a really compelling reason. And he said, I don't like substantive due process, and maybe we should rethink things like same-sex marriage and right to, he just sort of like he
right to
looks
contraception,
like
right to same-sex marriage, all these, rights
Exactly.
that Supreme Court have ruled on and said yes. And now he wants to kind of take that genie out of the bottle too.
Exactly. And he can't do it by himself. But what he's basically signaling is, I'd love to do this if you give me a case and I can talk my fellow justices into it. Justice Kavanaugh's opinion was more like, he tends to equivocate. And the important thing about Justice Kavanaugh's opinion is that he claims there is a constitutional right to interstate travel that will allow women to cross state lines for reproductive care that is precluded in their home state. So you can't get an abortion in Texas, no problem. Get in your car, drive 1,000 miles to a state that does have abortion. Forget about it.
So he's kind of creating a loophole.
Yes. Well, he's saying that he thinks a loophole exists, and there are a lot of people who disagree with him. And that's what's important, because I've heard people who aren't lawyers say, oh, but Justice Kavanaugh says you can travel. And I'm saying, you know what? We don't know that yet. And in fact, I think some really creative anti-abortion folks are going to say, well, wait a second. Maybe a woman has a right to travel, but the fetus doesn't. I mean, the fetus has a right to travel, but the fetus doesn't have.
It's being taken against its will by the woman to a state where it's going to be aborted.
Exactly. And that resident fetus of Texas might prefer to live and be born in Texas. So I think Justice Kavanaugh made a few people feel better, and I don't think we can count on it. The 3 dissenting justices, I think, have the much stronger argument. But the most important thing that I think we take away from the justice side, from a reality check, we're not living in the the 1700s of the Constitution, is they said, this is not simply returned to the states. That's what the majority would like you to believe. Let the states decide, the elected officials decide. They said this is the beginning of the interjurisdictional wars. And that's what we're seeing. So the last thing on this slide is sort of how the court framed it, which is why I think it applies to us in the ART field, which is the court said that what distinguishes sharply the abortion right is that it destroys potential life and the life of an unborn human being. And because of those 2 quotes, Roe and Casey are totally inherently different and unique from everything else. Well, if you substitute embryo, I don't see the sharp line that they're making. And the dissent actually says IVF and other things like miscarriage treatment, etc., could all be implicated. The court wants us to believe that Roe and Casey involved a critical, moral, unique question that is different from anything else. So they say, don't worry about Justice Thomas's, concurrence. Don't worry about anything except abortion. And I think the rest of us are all, sitting here worrying a lot about everything else.
And that kind of brings up an interesting question about the language, and specifically, each state now has different language of how they define abortion, what's the timing, and then, as you talk about the embryo, are there rights for an embryo? So let's talk a little bit about, there are some states that are defining personhood or life at the time of fertilization. And you had, you brought up Dr. Howard talking about a pre-embryo. So let's talk a little bit about, the devil's in the details and the language of different states. And I think Louisiana is an example of one state that takes a very hard line on life, whereas, maybe some other states are, well, we don't consider it until the fetus is implanted or there's a heartbeat. And can you talk about a little bit of the differences of that?
Yeah, and it's really confusing. So I apologize in advance because I'm confused. There's a couple of different elements of this question. So one is, do the statutes define a fetus as at fertilization, as you said? And there were as you all know, there were personhood bills that have been floating around for a long time that simply say life begins at fill in the blank. Conception, which is not a medical term and is confusing. Implantation, is better, et cetera, et cetera. But they are getting smarter, anti-abortion personhood folks, and they're using fertilization more and more. And that, I think, becomes very hard to say a pre-embryo, an embryo, a fertilized egg is not fertilized, is not an egg that has been fertilized. So when those definitions are in these statutes, I think we have two possible problems. One is they may be literally or explicit or expressly impacted by an anti-abortion statute ban. If you drop the embryo in the lab, God forbid, did you just kill a person? That's the most draconian interpretation. I think there's another problem, which is even if the statute has most statutes will have definitions and then prohibitions and then penalties. So if the definition applies to an embryo, a fertilized egg, the prohibition is simply an in utero pregnancy cannot be aborted except for life and danger to the mother, rape or incest, then you don't have a penalty to the embryo inside that statute. But you may well have another statute that says anybody who harms a person, anybody who negligently or intentionally kills a person could apply to an embryo. So I think the definition inside these statutes, regardless of whether the action item, the penalty and the crime or the civil liability and the penalty is still not, it's not good enough to say, look, all they're talking about is don't have an abortion. It's better than having it broader, but it doesn't get us out of the woods and out of the worry, in my opinion. And so that's sort of where I think we really need to be sort of vigilant. I was looking, the most recent, there are very few of these statutes, by the way, that carve out IVF. Indiana carves out IVF. West Virginia carves out IVF. They're the most recent. South Carolina tried to, but the bill failed. And what I've heard is that the next one may come back that is not going to have the carve out. And in Indiana, as you know, there were Republican legislators who objected to the law because they said it was too, it wasn't strict enough.
So to paraphrase, we can have the we can have the ban on abortion, which the penalty is what someone is doing if they do it, if they have an abortion or if the doctor performs the abortion. But the unintended consequence could be that an IVF lab in that state who's handling an embryo, someone could come and make a case, a prosecutor could come and make a case and say, well, wait a second, we've defined the embryo as a person and it's now manslaughter because even though the embryo, it's not technically abortion, the embryo is a person, has rights, and because that dish was dropped, or you could say PGT, we know it's very safe, but an embryo that's discarded, you've now discarded an embryo, and that was akin to manslaughter.
I think those possibilities are not science fiction. I mean, you mentioned Louisiana, and Louisiana is a fascinating state for this. Those of you who don't know, Louisiana, the reason it's got such different laws than much of the United States is it was based on the French Creole system. And so for a very long time, like decades, it has had a law that says embryos are juridical persons. They should be recognized in the eye of the law as a person. And for the patients who no longer want their embryos, the IVF physician can become the temporary guardian until recipient parents are found for adoptive implantation, and they also say adoptive implantation parents, the perfect ones are heterosexual couples, married couples.
So a couple
So-
with leftover embryos could be forced to donate those embryos to another couple to have a child.
Theoretically, that is absolutely right. What I've heard for years, and I thought every IVF clinic in Louisiana was shipping their embryos to another state.
Yeah.
But recently, after Dobbs, where, as you all know, people are calling their doctors all the time saying, I want to move my embryos, I'm hearing that Louisiana patients are doing that, which means that they didn't move their embryos out in the first place. There's also a really interesting thing from an old case. I don't know if you have the Ochsner Medical Center down in Louisiana, but Ochsner had a problem, which was they did not do a great job labeling their embryos. So a couple went to get them, and those of you on the call who are embryologists will kind of laugh, but they used to use masking tape. And masking tape doesn't do great at freezing. And so when they opened up the lid of the tank, they found a lot of pieces of masking tape floating at the top, unattached to.
That's scary.
Gauze. Yeah. And so there was a lawsuit brought, and the question was, did the embryologist commit medical malpractice? And med mal, the reason you want it, if you're the defendant, is there's a tribunal that has to say, yes, this was so egregious that you deserve to be sued, or no, we're going to protect you. And the court said this wasn't medical malpractice. This was the embryologist. And just to insult you further, in case you're on the call, they said it could be a high schooler. An embryologist could be a high schooler trained, which I thought was just like, oh, the most insulting thing I'd heard from my colleagues on that side. But what was so interesting is here's a state that has this law that says embryos are juridical persons, and yet there's no med mal if you do something that makes them unviable and unusable. So, even Louisiana isn't real comfortable with where they sit, but I also think they could be a blueprint for the future in terms of how we look at embryos.
So in that sense, it sounds a little bit more comfortable, like that even in these states, from a liability standpoint, there is, you can always have, a person, anybody can file any lawsuit at any time, but is there precedent around liability for an embryologist? Is there precedent for if someone moves from one state to another to come to Boston IVF, for example, sends embryos to Boston IVF? Is there precedent around even the patient coming here to get transfers or having PGT and embryo discarding in a state that doesn't have an abortion ban?
I'm not aware of any precedent about, especially because this is also new, a restrictive state that is coming after people from moving their embryos. And I think a lot of people are doing it. And one of the interesting consequences is going to be people may stay in those states to do their treatment because it's safer and they don't want to keep moving embryos around. The question of have embryologists been sued for things that happened in the lab, the answer is absolutely. The question I think that's harder to address is what were they sued for and what legal theories applied. And until Dobbs, none of that I'm aware of, not a single wrongful death claim has ever been successful. And there have only been a handful, but after the Ohio tank failures, a couple of those couples tried. In Illinois, a couple tried and said, we consider our embryos children, and therefore this is a wrongful death case. And the courts have said, no, 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 no. I don't know what will happen post Dobbs in a state that says, nope, or Louisiana. Louisiana wouldn't do it with the Ochsner, but that's probably a 15-year-old case. I don't know what happens now. And like you said, anyone can sue for anything. And I think, the risk, I think, is right now that passion is running so high and people want to get elected, and they're all running to the most extreme positions they can, the state legislatures. And if an attorney general, the attorney general in Texas has made all kinds of statements about, he's going to prosecute everybody. He's going to prosecute a law firm for paying for their employees who may want to go to another state, claiming they're, so you get an ambitious attorney general who wants to make a name for himself. I think we have a potential publicity seeking lawsuit type of thing.
I'm not sure if you heard, but I think it was yesterday that the current governor of Georgia, who is up for re-election, has made a comment that he believes IVF has a problem with all these embryos. And a supporter asked him about it, and he said, yes, he would like to change it so that, there is a consequence to having embryos in freezers in the state of Georgia, which would be, very, very concerning. Do you think, though, so have you seen any changes in consent around embryo freezing or discarding in these states, or is it still too new? And then, do you expect is there a difference between a 2PN embryo and a blastocyst? Or is there just not enough distinction that the court could even know the difference? My own thought is, if people understood what a blastocyst is, and it's a ball of cells, and it's very different than the pictures anti-abortion people have of fetuses. We're talking about a ball of cells that you probably wouldn't know the difference, whether it was a human, a bovine, or a mouse, apart from size. So we're talking about things that, people don't even have a conception of, is this really, it's clearly not viable, and it's not implanted. And, it's kind of an interesting distinction to make between a 2PN and a blastocyst.
I haven't heard anything happening on the ground about that. It's interesting. For a long time, we used to talk about, or Dr. Howard in particular talked about, until a primitive streak and individuation appears, embryos, pre-embryos should all be fine, because he would say, how can it be a person if you don't even know if it's one person or two persons? And whether it's going to twin. So I guess I have two totally inconsistent answers for you, David. One is, they're not going to care. And the minute that egg hits, sperm hits the egg. And the other is, I spent a lot of time studying all what I call the divorcing embryo cases, which is the husbands and wives fighting over their embryos. And one of the things I've often thought was important to communicate to people I talk to is that the courts are very happy to get expert testimony, and they use it very well. And so even though my embryology colleagues have, sort of scoffed at pre-embryo, the courts really like it. And the courts use it to differentiate between an embryo in the uterus and an embryo out of the uterus. So you have these cases saying a pre-embryo, a zygote, whatever you call it, is not an unborn child. And so, putting aside what the right label is, and I think that's a moving target, I think having the medical scientific community available to educate legal decision makers is a really important role to play. Whether it will be persuasive right now when the heat is so high, I don't know. I heard a really interesting bioethicist perspective on what are these new laws, what are they? And they said, well, they're morality laws, that's a given. But the question we haven't figured out yet is whether or not they are largely symbolic, like prohibition, we don't like alcohol, or are they the true believers who want to really enforce restrictions like the Salem witch trials? So I don't think we know yet. And I think especially leading up to the midterms, there's a tremendous pressure to sound like you are going to do the Salem witch trials. And I don't know what we're going to find. One thing you asked me about, have we seen changes? I haven't, but I think that it's important to think about Arizona, before Dobbs, wrote a law after an oncofertility patient did not get her embryos when she wanted them from her ex-husband because they had agreed that unless they both agreed she couldn't. The legislature wrote a statute that's on the books today that says, if there's a dispute between the two people, the progenitors, if it's different if you use donor sperm or eggs, if there's a dispute, the one who wants to bring them to life should get them regardless of anything they wrote at the clinic. So that's another fear of mine, is even if we don't change the forms, are they going to be viewed as unenforceable under some new state laws?
I think the whole divorcing embryos and embryos as property, or having a special status, and can you force someone to procreate, is a whole nother topic, and a very interesting topic that I know you've done a ton of work on. Maybe just we're reaching time, but this is still a very changing and evolving area because it's just happened so recently. But if you could leave us with a thought of, what do you see in terms of reproductive threats? What do you see as the biggest potential threat to IVF? Is it something that you see as more state by state, because that's essentially what Dobbs has said, let the states decide? Or do you see it more as a national ban? Biden made a comment, I think today or yesterday, that if the House and the Senate stay Democrat, he wants to put a bill forward, at a national level. But so what do you see as the biggest legal threat to us as an IVF community?
I think it's going to stay at the state level for a long time. I mean, I think it's wonderful Biden thinks we could get a law passed. I doubt it will get it. It's possible. We weren't able to get it when we had majorities on both sides for the past decade, off and on. So I think the biggest threat is state by state. And I think this, what you said, Kemp did yesterday, I think this embryo target, I think there's a target on the back of embryos by those who are incredibly ambitious anti-abortion folks. And some states are going to see that really quickly, and other states are going to be perfectly fine. I think you're going to have patients coming into places like Illinois, Massachusetts, and California. And I think that's going to be reassuring for them. So I think embryos are the easy target because they've been talking about it for a long time, and there are true believers, so to speak, who really want to shut it down. And that's going to be a red state issue. I don't think they're going to get it on a national level unless they get the Supreme Court. The Supreme Court just turned down another case, I think, that would have been worrisome. The second thing I see it in is surrogacy. And I think, we've always said women control their own bodies with regard to procreation, but I just can't believe this isn't impacting us. Where surrogates come from, where they're allowed to travel, what they agree to, what happens if they end up in a red state and something's wrong. We're not going to, selective reduction, those things just around pregnancy and third party pieces worry me.
Well, Susan, again, thank you so much for your time.
One
of the things, you wrote an amazing review of this for the ASRM Legally Speaking column, so we'll send that out so everybody can read it. But it's a very nice, if people are interested in it, diving into some of the dissents, excuse me, and more about Justice Thomas and Justice Kavanaugh, and then also Justice Roberts, who maybe tried to do something but wasn't able to swing some of his more conservative colleagues into having that narrow decision that you were talking about. So we'll send that out to our entire team. And again, thank you so much, Susan. Really appreciate having you with us today.
Thanks for having me.
Yeah,
it was a pleasure. Thank you.
We'll continue to look for your guidance in what happens into the future.
Well, you'll read. I say freeze eggs, not embryos, and that will go a long way to helping. But there's a lot going on. Thanks for having me.
Thank you.
Thank you for caring so much about this. I appreciate it.
Thanks everyone for joining us.
Okay, bye-bye.